Hi, my name is Juliana Manzanarez, and I'm an attorney here at Ibarra Maldonado Law Group. Welcome back to our second episode ever of Ask Juliana. We started last week with just a general overview of what cancellation of removal means for people who are in immigration proceedings. So now we're just going to, for the next couple of episodes, kind of parse out each one of the elements for non-permanent resident cancellation of removal. Remember, for non-permanent resident cancellation of removal, the individual has to be here continuously for at least 10 years, be a person of good moral character, has not committed certain criminal offenses, and the deportation would result in extreme hardship to their qualifying relatives. So we're going to go over each one of those elements in detail in a different episode. So today we're going to talk about the 10-year continuous presence, what that means, if the individual leaves the country or unfortunately gets deported at some point, what that would mean for then applying for cancellation of removal. So when it comes to the 10 years of continuous presence, there's two things to keep in mind. Some instances will terminate continuous presence, which means that the clock can't restart the 10 years, and some things will break continuous presence, which means that the clock can restart. To meet the first requirement of non-permanent resident cancellation of removal, the individual has to show that they've been continuously present in the United States for at least 10 years. So that brings up two questions. One, when does the 10 years start and end? And two, what effect does absences have on the 10 years? So there are certain instances that would terminate the 10-year clock, as we call it. And then there are other things that would break the clock, the time. So termination, one of the ways that would terminate the 10 years continuous presence is by service of a valid notice to appear. So a notice to appear is a document that ICE or the Department of Homeland Security gives an individual, essentially giving them their immigration charges, and it must state why they believe that the person is removable or why they can deport the individual. There's been some recent case law in the last year about what exactly is a valid notice to appear, what service means, and our great attorney Ray did a Facebook Live on it a few months ago, so I would invite you to check that out to get more information on what a valid service would be and what that new case means going forward. But generally, if it is a valid notice to appear, then what would end up happening is that whenever the individual receives that notice, it would terminate the clock. So an example would be if an individual has lived here in the United States since April of 2008 until now, 2019, and they were served with a valid notice to appear in 2017, they wouldn't have enough continuous presence because the clock stopped in 2017. So they would only have 9 years of continuous presence instead of the 10. So one thing to keep in mind is that if that's ever happened to you or you think that, oh, maybe that might apply to me, just make sure that you go see an attorney to make sure that you actually do have the 10 years continuous presence, because that is one of the things that you have to prove to be able to win your case. Another instance that would terminate the 10 years is the commission of certain crimes. And we're going to go over that more next week because some of these crimes also will kind of kick you out to be able to apply for this type of relief. Just keep in mind that that could also go to continuous presence, not just good moral character, which is another element, but we'll explore all of that next week. The third one is if you or if an individual leaves and it's called to a formal departure. So that would mean that they got an order of removal from the judge, expedited order of removal at the border, they took a voluntary departure at some point. So if you've ever had an immigration encounter, I would suggest again to come talk to an attorney to see how that would affect you, either if you're in immigration proceedings now, but also just to be prepared in the future. Hopefully it never happens to you and you never have to deal with it, but it's always better to be informed. So just make sure that that isn't going to be an issue for you. So the other way that continuous presence can be interrupted would be a break. So a break differs from termination because after the break, then the 10-year clock can restart, unlike a termination. So a break in continuous presence would be if an individual left the country for more than 90 days at one time, or if they have multiple entries and exits that add up to more than 180 days. So this is also why it's important for individuals, even if they have never been caught by immigration, to just be forthcoming with your attorneys so they can be able to do a more thorough analysis for your case, because the worst thing that can happen is that you don't disclose everything, and then as attorneys we can't help defend you if we don't know that information. So those are the in a very brief way how you can interrupt continuous presence. The other thing that I wanted to talk about a little bit is how do you show that you've been here for more than 10 years? Because this is all evidence that you would have to submit to an immigration judge. So some ways can be children's birth certificates, rent receipts, mail that was addressed to the individual if there's a postmark to it, tax returns, medical records, school records for either yourself or your children, letters and declarations from people that have known you, that can say, yes, I met this person back in 1995 at this place and time. And among other, family court proceedings, maybe other court documents, maybe you got a speeding ticket at one point that has a date on it. These are all things that you can use to show that you've been here for at least 10 years. So that's it for today's episode. Thanks for watching. Next week, we're going to talk about the good moral character requirement, what convictions can present some issues for you in your cancellation of removal case or an individual's cancellation of removal case. So thanks for watching. Make sure you subscribe to our YouTube channel. And again, if any of these apply to you or you think it could apply to you, just come get your case evaluation here at Ibarra-Maldonado Law Group. Give us a call at 602-910-4040.